Hey, Larry.
Hi, Andy.
How's it going tonight?
Going well.
Did that Uber show up?
It has not shown up yet.
I got to get with them. I spent the money and they said they'd be there, but I guess I need to work on that better.
So I think you're trying to get rid of me.
I'm trying. Please consider making us part of your podcast diet. You can find us at Registry Matters on your smart speaker or podcast app of choice like Google Podcasts or Apple Podcasts. Also, if you like what you hear, please write a review. If you don't, forget everything I just said. You can support us at patreon.com/Registry Matters. You could find us on Twitter. We've been getting a lot of Twitter activity lately. And then also, something very exciting for us is we received a very generous PayPal donation from Mr. Anonymous. And he's the one that voiced in a question for us last week. Endless thank yous and greatly appreciated. So we are joined this week by Miss Lea Bickerton, and she is a practicing attorney in the Pittsburgh, Western Pennsylvania area at Bickerton and Bickerton Attorneys at Law. And while doing research for tonight, I discovered that you're a multiple-time recipient of the Rising Stars Award from superlawyers.com. We're very fortunate to have you joining us tonight. Lea, good evening. How are you?
I'm doing great. Thank you for having me on.
Thank you for joining us. It's really so much appreciated. So I guess you come into the fold with the registry stuff with the Megan's Law decision that went down in Pennsylvania several months back.
Yes.
How did you come in to be involved in that case to begin with?
Well, I first got involved with sex offender registry issues back around 2011 and 2012. That's when the Adam Walsh Act first came into effect, and some of my clients noticed that their registration periods were going from 10 years to life, and it's something that they found rather upsetting.
No doubt.
So at that time, the strategy that we were taking was to basically try to get their sentences terminated quickly, so that way they would be completed before the new law took effect, and that way their registration terms wouldn't be increased. So that's pretty much how I got started in that. It was just kind of something that was incidental to my existing practice. And it just kind of evolved from there with the evolution of the Adam Walsh Act and people having the consequences that they thought were going to happen as a result of their guilty pleas, having that changed was rather upsetting for them. So I dug in and started fighting in any way that I could.
And Larry asked me this question or brought it up this morning when we were talking, is that you guys aren't clairvoyant. You're not, you can't see the future to know that they're going to increase the punishment later down the road.
That's correct. I guess that's not completely correct. If a law has been passed and people are in the process of entering a plea, then it's kind of an attorney's duty to be aware of that and to give their client a heads up that, hey, although this is the consequence that you have now, be aware of the fact that it's something that could change in the future. And although one would hope that they wouldn't try to make something like that retroactive, our clients tend to prefer to be prepared because you never know what might happen with the law.
I'm being a little silly, but I mean, if somebody was convicted of something in the 90s, there was no forethought of something changing in 06. So that I'm just being kind of silly about those changes.
Right. And I think that if you're cynical, it's something that, you can kind of see that the powers that be may attempt, but it's something that should not happen. The consequences of a conviction and the consequence of a plea should be whatever it is at the time that you enter it. It's not really fair to come in after the fact and just change it up on people. So that's something that it shouldn't happen. But as we've seen over and over again since 1994, it's something that has happened.
Right. Are there any updates on the latest Megan's Law changes?
Since the February 2018 law, it's the Act 10 in Pennsylvania.
Okay.
As far as that particular shift, I believe that the Pennsylvania General Assembly just passed some new modifications to that within the last week. Unfortunately, I'm not certain of whether Governor Wolf has signed those into law, but that has been the latest change. So over the last 10 months or so, there's been a lot of shifting as far as Pennsylvania law is concerned for the sex offender registration.
So that change that was made, they ruled unconstitutional. It was going to pull about 18,000 people off the registry. And so now the legislators have gone back to try and pull, I guess, at least some of those 18,000 back into where they'll stay on the registry?
Yes.
Do you know any specifics behind it?
I don't know the exact numbers, but I do know that the state police has gone through and they've conducted a review of a lot of the people. And for individuals who had offense dates from before December 20th, 2012, they're basically going back to what the original registration periods were. So for someone who had no registration as of, December 19th, 2012, they're supposed to go back to that. For individuals who had a 10-year registration, they're supposed to go back to that as well. Where we're seeing some slow shifting is for individuals who have out-of-state convictions.
Right.
And one of the issues with that is that sometimes the state police will reclassify that offense. So even though the person was a 10-year registrant until December 20th of 2012, now the state police is saying that, well, now that we've looked at your original offense, it looks like you should have been registering for life to begin with. So that's something that we are seeing. But ultimately, for individuals who had convictions from the pre-Adam Walsh Act period, it's reverting back to the original registration term. Now, as far as the registration obligations, that's a little bit of a different story. The internet component was something that was not present for people who were convicted before 2005, but that's something that has been reinstated with the Act 10 of 2018 that was passed in February.
And when you say internet, is that people being on the website, or is that where they're having their internet usage restricted?
Oh, no, I'm sorry. It's with having their information on the internet as far as, name, picture, address of employment, all of that information.
Yeah, I've noticed that Pennsylvania does do both ends.
Yes, they do.
Larry, do you have anything?
I'm just sitting here soaking this up because it's so fascinating that despite what we predicted at NARSL that they would do, what the legislature is actually doing, which is trying to, in their view, contain the damage. They see the Menez decision to be damaging to public safety, and they're doing everything they can to try to have as much registration obligation as they possibly can. And I'm always the bearer of bad news, telling people this is what I anticipate they will do. But this is what they will do in most instances, and this is what they are doing in Pennsylvania. So I'm not surprised. You do anticipate we're probably going to have to litigate at some point once it becomes clear what the new requirements are, because it looks like to me they're reaching as far as they can, and some of their reaches may be problematic.
I know there are several cases in the works where people are already litigating to fight this out and to get it back to a place of fairness and to hopefully get what the spirit and, in all honesty, what the language of the Munez decision said, which is that, there are certain aspects of the registration obligations that were punitive and shouldn't be imposed on people whose offense dates were before a particular point. So hopefully we'll be able to get that back to where it should be.
Well, there was a 1-year ramp up period. They passed this thing in 2011, and it took them a year to make it effective. They had 1 year to ramp up, so that would have given attorneys some chance to be aware that, as they did their pleas, that there were changes. Did you encounter attorneys who did not bother to know that there were changes coming December 20th, 2012? And did you end up having clients that were shocked that they thought they had a 10-year obligation? That's what their attorney had told them, and they ended up with the requirements of December 20th, 2012 fresh to them? Did that happen?
That did happen a lot, and there was actually a little bit of a shift in the state in the case law to handle that particular circumstance, where ultimately for an attorney who misinformed their client by saying you weren't going to have a registration obligation or you were going to only have a 10-year registration obligation, that was something that it's ineffective assistance. If the attorney should have known about this change in the law and did not make their client aware of it and misled them about that particular consequence, in Pennsylvania, if an attorney misleads about the registration obligation, that's considered to be ineffective assistance of counsel.
That's consistent with what we have in our state on the case law, that if they misadvise either deliberately or they're just wrong, most people consider that a critical part of the negotiation. That's a heck of a collateral consequence. And if they expected no registration obligation or a 10-year and they had lifetime, did the prosecutors rigorously resist those withdrawals of pleas, or did they say, yep, you're right, it was an effective assistance of counsel?
They fought at first, but once the precedent changed, then they began to concede the point.
That's good. Okay, and let's go on. I don't want to spend all her minutes on this.
That's fine. I get it. So Mr. Anonymous phoned in and he has a question. And since we have an actual attorney on, let's see how this goes.
Hey, it's me again. Larry, I hear you have some strong opinions on what I brought up in my other voicemail regarding pro se litigants asking the wrong questions in court and how dangerous that can be. I wish you'd elaborate on that point for your listeners and for me. Thanks. Bye-bye.
So why don't you two bat it around and tell me what y'all think about why people shouldn't do pro se litigation?
Well, I don't say they shouldn't. I just think it's very
okay.
It's
unadvisable.
It's generally not a good rule, but I'll let Leah tell us what often goes wrong with pro se litigation that we try to put together after they've run their case in a haphazard way.
Right. I think that a lot of times what you have is, and this is something that will go for people who are going pro se that aren't attorneys and people who are going pro se that are attorneys and are operating outside of their practice area, or at least the field that they're knowledgeable in. And one of those problems is that you don't know what you don't know until the court told you that you didn't know it. And where that becomes a problem is that in order to preserve certain arguments and to, win, it's not just, knowing inside that you're right. It's asking the right question and doing it in the right form. So what we see a lot of is where an individual isn't aware of the fact that they have to present a legal argument in a particular way. They have to raise particular claims at a particular point. So if you don't raise it in front of a trial court, then it's considered to be waived and you can't raise that in the future. And the fact that you're representing yourself isn't something that's going to help you later on down the road. If you do choose to represent yourself, you're taking on the risk that you're not going to do it properly, and that's not necessarily going to save you. Courts do tend to give pro se litigants a little bit of leeway, but if you make an error that results in waiver, the fact that you're pro se is not going to save you. So even though you might have a really good issue and a really good argument, if it wasn't preserved properly, or if you just didn't raise it at all, that's something that can be lost, and it will cause an attorney for later on down the road. It's going to give them fits to try to figure out how to get that back in front of the court to try to get you the relief that you're entitled to.
I guess let me try and pull it into layperson terms. If I go out and I work on my car, I'm doing, we'll call it pro se working on my car. I've got a book, I'm going to spin some wrenches, and I'm going to fix my car. If I screw it up, the consequences are just for me and my car. And that can be, maybe a couple $100 down at the local mechanic will get that fixed. But in the case of actually bringing something to a court, that can then set precedent that would then have far-reaching consequences, not just for me, but for all the people that might bring litigation for the next 10 or 20 years.
There is the risk for that. I think that where you have, it's something that I don't necessarily think that happens that often, where a bad precedent comes from pro se litigation. I generally think that as far as pro se litigation is concerned, it usually does have a greater impact for the individual. But, there are some circumstances where a court has been waiting for the right facts to address a particular question of law. And if it happens to be a pro se litigant that's bringing it up, where there's a particular problem is that if that litigant doesn't argue the issue properly, right, then yes, you're going to be set with a particular precedent. And once a higher court has determined to, rule on that, they're not going to revisit it for a while. So that's where I can see the problem with that, is that if you do it wrong, yes, you do have the potential of locking that in for 10 or 20 years, or until a court recognizes the fact that, it's time for us to go ahead and revisit this particular issue. And I think that where sex offender registry issues, where that's a little bit of a problem, is that a lot of times courts aren't necessarily ready to hear an issue until they're ready. In Pennsylvania, individuals were trying to challenge the constitutionality of the retroactive application of the Adam Walsh Act for 7 years. They were attacking the punitive nature of sex offender registration laws in Pennsylvania for even longer than that. And it's an issue that the Pennsylvania Supreme Court didn't really address in depth until the last 2 or 3 years. So if the case that they had decided to pick up was one where the issues weren't argued properly, it would be safe to say that it was going to be a long time before the Pennsylvania Supreme Court would be prepared to revisit that particular issue because it is so controversial.
Right.
And it's kind of like it's a little bit of a third rail. There are certain issues where they're going to deal with it as rarely as they can. And if they can avoid it, they're going to look to it because there are certain things where it's not. There are political issues and there are very controversial issues. And if they don't see a very good reason to revisit it, they won't. So that's where pro se litigants do run the risk of harming their own legal interests and the legal interests of others.
Larry?
I would like to add, Andy, that the people pro se often forget that the neutrality of the judge. The judge is not there to be your advocate.
Right.
If you take on the responsibility of representing yourself and putting forth your claims, the court expects you to be familiar with the rules. The court expects you to understand the law, and the court expects you to be able to articulate. They're not going to coach you along. You might run into a small claims judge or something at a very low level where there's not the expectation that the parties be attorneys, where they may give you that help, but you're not going to be coached by the judge. That judge is a neutral party, and they somehow or another think that the judge is going to help them through this. And that's not going to happen. If you waive your objections because you don't raise them, they're waived.
Right.
If you don't do proper cross, it's waived because you didn't do it. You didn't know how to do it. That's not the court's problem. And
you can't go back and do it later.
When my boss became a prosecutor, he was just in the DA's office, and they put him in the DWI Metro. And I was already a little bit more informed about the law than the average person was, and he was doing a DWI trial as a prosecutor, and he had the officer read from the breath card before he'd laid the foundation. Read it, and so the officer said, "You want me to read the score?" And he said, "Yes, just read the score." And I think Leah can figure out what happened after he read the score without foundation, and so the card had not been admitted, and therefore he could not be reading from the breath card. But so the officer tried to help the prosecutor. "You really want me to read this?"
Well, let's move on. So there's this article from the Cato Institute, convicted of violating a law that does not exist. And this one kind of goes about 3 or 4 levels above my head. But if I understand it, an individual was convicted of a sexual offense prior to SORNA, and he ended up getting transferred from a prison in Pennsylvania to a halfway house in Brooklyn. And according to the way the things are set up, that counted as interstate travel, which I guess means that he was then obligated to register in New York. And because he was convicted of a sexual offense, he wouldn't necessarily have been required in Pennsylvania, but now he's in New York. Now he has to register. He never did. So now he gets jammed up for not registering for something that he was never obligated to register to begin with. Is that how this works out?
Unfortunately, yes, because the way that courts have addressed this particular issue is by saying that the criminal activity isn't necessarily based upon the conviction date. It's the failure to register at the time that you fail to register. So it's whatever the law happens to be when you fail to register. And I think that there are some courts that are starting to disagree with that, where if you have an offense that didn't necessarily come with some type of registration obligation at the time, then they can't go back and retroactively impose some type of registration requirement on you. And I think that with this particular case, I believe it might be the Gundy case.
It is.
Where it's kind of interesting, and I think that the United States Supreme Court is finding it interesting as well, is whether there was really proper authority to make that particular individual register retroactively. Because the statute didn't necessarily call for retroactivity, it left it to the discretion of the Attorney General. And I think that what's really fascinating about the issue that the Supreme Court is looking at is that they're getting into the non-delegation doctrine, which is something that the Supreme Court really hasn't gotten into since the 1940s. And it's a fascinating principle, and hopefully it's something that will bring some reason to all of this. Because there is, the serious question, well, should the legislature just kind of leave the determination of whether someone should have to register to the executive branch? We have separation of powers for a reason, and circumventing that to deal with sex offender registry issues is not appropriate, in my opinion, and hopefully the U.S. Supreme Court would agree.
And Larry, I think we covered something not too long ago about this non-delegation doctrine stuff, didn't we?
We have talked about non-delegation. I haven't read the briefs in Gundy, so I'm going to be a little bit in the dark here. But what will be interesting, if he had an offense where at the time he got that offense, that there was a registration obligation for that offense in the jurisdiction of conviction, and he got convicted federally. But he say he got convicted in Georgia, and they had a registry in Georgia at the time he got convicted, and I shot him out to Arizona to do his time, and then transferred him to New York to the halfway house. If he could have reasonably anticipated he would have had a registration obligation, that's a whole different issue in my mind for the court to unpack than if he had no idea, if his conviction was so old that the registry had never been thought of. What I'm getting at is if he had any expectation that he may have to register, that's different than if he had no idea that his criminality would bring him within the zone of registration, because the Adam Walsh Act, in my opinion, cannot force a state to register you if your offense is not registrable. If the state says we don't want this registration here, once you present yourself for registration and make an effort to register, and they say we don't register you, your crime is too old, our state would have dozens, if not hundreds, of people who would be federally prosecuted because we don't register anyone who was off paper by July 195. We don't care what they were convicted of. So when I get the details of the offense fully digested, I'm going to have an opinion about which way the court's going to go, because it's to me different depending on what his particular circumstances were.
That's why this is way above my head, because this is...
Well, the non-delegation clause is a separate matter. The 2006 Adam Walsh Act, the Congress said we don't know what to do with pre-act offenders, because there are people who had crimes that predated the offense, and there are people that were already registered that had shorter registration obligations. So they threw up their hands and said, Alberto Gonzalez, you do what you want to do. And Alberto Gonzalez said, oh, well, it applies to everybody.
Right.
And that's when he issued the rule that said it was retroactive. So that meant that green lighted the states to go ahead and increase their obligations and to reach back and get people. But that's the issue, one of the issues in Gundy, maybe the only issue, but I haven't read the briefs. But it's going to be interesting to me once I read them to figure out what his particular facts were, because if he had an expectation he needed to register, when he got to New York, in my opinion, when he was in the free world, he needed to check in and say, does your state law cover my federal offense, yes or no?
And somebody on Twitter gave the question, says, Gundy is kind of an interesting case. Though they granted the cert petition on only one of the 4 points that were raised in the petition, non-delegation, I think it might be interesting in light of Gorsuch's recent concurrence blowing up civil criminal distinctions.
Yes, Sessions to Maya. When I saw that concurrence, I might be considered one of those constitutional law nerds, but when I saw that, I got excited because it looks like Justice Gorsuch has had some opinions about the non-delegation doctrine and, the role of proper limited government for a very, very long time. And seeing that concurrence, I think that lends more credence to the idea that, as far as Gundy is concerned, this might be interesting as far as how they're going to rule as far as the non-delegation doctrine is concerned.
Can you dumb it down for us? I don't have any idea what this means.
So basically what they're saying is that when the legislature has opinions about something where they're trying to speak for the people on how the law should operate, they need to be specific about it. So this is how we'd like it to be. But you know what? Executive branch, you all figure out how it is exactly that's going to work. And where that's fundamentally unfair is that the executive branch, they're responsible for figuring out who they're going to pick up and throw in jail. So having the same people who have the authority and the responsibility for determining who they're going to throw in jail and pursue charges against also define the scope of how the statute is going to work. It's just not fair. That's not what the Constitution is providing for. The separation of powers exists for a reason. It's to protect the people, and it's when any time you give too much power to someone who is also responsible for enforcing the laws, that's where you see issues of mass incarceration,
right?
And all all of those negative things that come out with one branch just being too powerful. That's why separation of powers exists. It makes sure that no one branch of government can trample upon people's rights. So I think that that's where the Gorsuch concurrence in the DiMaia decision is really showing where he has concerns about government operating, where they're throwing out specific standards that are a little bit too vague and letting the executive branch just kind of fill in the gaps.
Right.
And I think that in the DiMaia case, it wasn't necessarily non-delegation. I believe that it was more about the anti-commandeering.
Right.
But it's still the same general principle of separation of powers, not letting one branch have the power to decide what the scope of their power is going to be.
I always bring up Judge Dredd. I mean, he would run around and he'd say, oh, hey, you're guilty of this. Okay, I'm going to give you your sentence. Your sentence is death. And he would kill you right there.
Yes.
That's not fun.
That's a problem because of why?
Yeah, I guess. Well, I was right. Yeah, of course. So yeah, if they are in the case of the administration now, they would take everybody and they would just round them up in a big dragnet and throw everybody away, or evict you from the country, just because that's how they think that they're going to be law and order, and that's the policies that they're going to pursue.
I think that we'd be kidding ourselves if we thought that it was just this administration.
Well, that's
I think
true.
That...
It just seems to be more prevalent in this particular administration.
Yes.
And we are almost out of time with having you join us. You are going to be at the conference in a couple weeks, right?
Yes, I will.
What's your topic going to be? What are you giving a presentation about?
I will actually be doing 2 separate presentations. On Friday, we will be discussing the highlights of the various cases and where the law appears to be going. We'll be covering a lot of the high points. We'll be talking about the Muniz decision. We'll be talking about other decisions like People v. Pepitone out in Illinois, which is the case that's dealing with whether certain sex offenders are allowed to go to public parks. We'll be covering those particular topics, just talking about what the major issues happen to be, where we see them going in the near future. And then I'll also be doing a little bit of a rundown on the sex offender registration issues in Pennsylvania.
Outstanding. If anybody wants to reach out to you, do you feel comfortable with giving out a Twitter handle or email or anything like that?
I think that Twitter is a very great way to follow me as far as, my various thoughts on things. My Twitter handle is @BickertonLaw.
Excellent. All right. Thank you so very much for joining us, Leah. It is really a privilege to have you on, and I look forward to meeting you in a couple weeks.
All right. I will see you in Cleveland. Thanks for having me.
Thank you.
Thank you, Leah.
Okay, bye.
Bye. Ready to be a part of Registry Matters? Get links at registrymatters.co. If you need to be all discreet about it, contact them by email, registrymatterscast@gmail.com. You can call or text a ransom message to 747-227-4477. Want to support Registry Matters on a monthly basis? Head to patreon.com/registrymatters. Not ready to become a patron? Give a 5-star review at Apple Podcasts or Stitcher. Or tell your buddies at your treatment class about the podcast. We want to send out a big heartfelt support for those on the registry. Keep fighting. Without you, we can't succeed. You make it possible. And we want to thank Leah for joining us tonight. And moving on from Wisconsin, I guess it would be Wisconsin Public Radio. Wisconsin Supreme Court, adults can be charged for earlier crimes. The way this one reads is that if you commit a crime when you're a juvenile, then they wait a handful of years for you to become an adult, and that's when they bring the charges on you. I guess ostensibly to bring you into the fold of charging you as an adult instead of under juvenile type laws.
I've heard of that, Andy. That's really shocking. And the Supreme Court said that's okay.
Well, it says the Wisconsin Supreme Court reaffirmed it. Yeah. So they're going to let that run. That sounds really kind of shady. Doesn't really sound... Yeah, I mean, if you commit the crime as a juvie, you're presumed to have less intellectual faculties as a child than you would as an adult.
Well, it does create problems for us when we have an adult person who has a juvenile offense. But we have to slice it and dice it. We would not be able to put the adult in the juvenile detention center if that were to be the desire of the court, because that wouldn't be appropriate. But the penalty should not change. The penalty that was available to, if the penalty was X, Y, and Z, that should not change when the person is charged. The juvenile penalty scheme should still be what they're subjected to, because otherwise, in my mind, that would be changing the penalty and increasing the penalty after the crime, and that would seem to violate the ex post facto clause to do that. But their argument would be, well, those are juvenile penalties, and we're moving them into adult court, and the penalty for that same behavior in adult court is different. But I just don't see it that way, because you were not subject to an adult penalty at the time.
But even in the article, they're talking, in this particular case, they're talking about someone who committed the crime when he was between 9 and 12. It seems like you could kind of argue, if the person were in their later teen years, that you could kind of bump them over the line to charge them as an adult, or wait for them to be charged as an adult. But, a 10 or 11-year-old, that's problematic.
You're seeing my point, though. The juvenile penalties for crimes are generally far softer.
Yeah.
And so the penalty that we would have available to us to punish a 12-year-old for a delinquent act, as we refer to it in my state, we wouldn't have that same penalty stream available for an adult. The penalty potential for an adult would be much higher. Well, if the person is prosecuted when they turn 18 for something they did when they're 12, I can see that if the statute of limitations hasn't run, you couldn't take that person and put them in a juvenile detention facility.
Right.
But you could give them the juvenile punishment. If the maximum they could get for that offense would be a probated sentence, then that would be a maximum we would impose on them, even if they were an adult. We wouldn't magically say, well, now this as a delinquent act would be subject to a probated sentence. No more than that, but as an adult, we can give you 3 years of incarceration. So therefore, we're going to sit and run out the clock and wait for you to turn 18. Then we're going to. I mean, that's just plain out wrong.
Yeah, I don't. Yeah, and you brought up the statute of limitations, and I was just thinking about that before you got there. Is it even remotely can you give me an average maybe, or what's typical for a state's statute of limitations on how long they'll let something before it's no longer prosecutable?
It's all over the board, because it depends on the severity level of the offense. A misdemeanor level offense is going to have a much shorter statute of limitations than felony level offenses. In some states, like in Maryland, there is no statute of limitations for felony, and it can be any felony. Well, in our state, the statute of limitations gets progressively longer for the severity level of the felony, and I don't have that in front of me to give you the exact spread on each felony, but that's generally the way it is. If you look at Arkansas, look at the states that haven't abolished their statute of limitations, the more severe the crime.
This one says felony sexual assault, which is pretty ambiguous as far as what it was.
It would probably have a pretty long statute of limitations. From 12 to 18, it would probably still be within the zone of prosecutability.
Do you think that the prosecution there purposely waited till 18 to go after it?
That does happen.
It just seems nefarious on all kinds of levels.
Well, but we elected those people by and large.
It's always, this whole podcast is going to be, it's your damn fault. Every episode is going to be, we elected the people that did it, so it's our fault.
Well, it's part of the podcast is to educate people when we're in a major election year. About 36, 38 states are electing governors this year, and then down the ballot we're going for a whole lot of offices. This is the off-year election where there's a lot of state level and local level elections. These are questions you should be asking throughout this campaign season when you have someone running to be your elected prosecutor, whether they call them state's attorney, district attorney, prosecuting attorney. You need to ask them these questions at the forum. You need to ask them, what do you think about prosecuting a 12-year-old as an adult?
Right.
And get them out publicly. You can record them. Everybody's got the capability of recording everything these days. Put these people on the spot and ask them, and you tell them after they say that, I don't agree with you on that. These are children, for crying out loud. They don't ever hear that. They hear just the opposite. They hear if you're old enough to do the adult crime, you're old enough to do the adult time. They seldom hear anyone tell them that they don't want this. So they believe that they're representing the will of the people when they seek this type of vengeance, is what I'll refer to it as. To put a child through, I mean, you're just barely, if they wait to turn 18, as far as the brain development, you're still a child.
Sure.
Particularly, the male brain doesn't develop, I think, if I got it right here, the male brain develops more slowly than the female brain. Do I have that right?
That's what I've always heard.
So we're talking about a less than fully developed brain, and we're going to put this person in adult penalty scheme for something they did, for a transgression they did when they're between 9 and 12 years old.
Yeah.
How do you sleep with yourself, Mr. Prosecutor? Tell me that.
Yeah, I don't know how you get there. I mean, we've had all these articles recently on just abhorrent treatment of how like the transport van for 18 days riding around in feces. I struggle with how the people are able to, like you said, sleep with yourself at night after you go. I mean, do you go home and you're like sitting there like cutting your steak at your dinner with your wife? You're like, man, I totally railroaded this kid that committed a crime 7 years ago. He's now 19. I
gave him 10 years on the adult joint, and he's going to get sodomized every night. That'll teach him. I mean, that to me, if you're 18 or 19, in all likelihood, you're still going to be bait for the older offenders.
Definitely,
it's tragic.
Well, let's move on to something even much more fun. Lifetime GPS tracking is not punishment, says the Wisconsin Supreme Court. Hey, we're just all full of Wisconsin today. And this is from Reason.com. This totally goes along with what we covered last week with GPS monitoring. And this article really touches on a whole lot of the various challenges of GPS monitoring. And Larry and you and I go back and forth on the benefits of technology and all this stuff. But I do see the limitation, and I said this last week, I do see the limitation on having your civil liberties potentially taken away by the failure of technology. And if your supervising official doesn't take into account some sort of leniency of that technology does kind of go down here and there or whatever, that your liberty should not be taken away based on this device saying that you're 3 feet inside of the zone, the restriction zone.
Well, the thing that troubles me about the technology is that it's the human beings who mess it up. The technology has its own flaws and limitations, but the desire with GPS monitoring when they're supervising offenders, rather than trying to use it as an assistance tool to figure out if a person is respecting their boundaries, or in the case where they've actually caught them in violation of curfew or boundaries, to use it to try to rein in behavior, they use it as an I got you thing because they know of these flaws. They have figured out how they can do an I got you moment. And they put people on these devices knowing that they're going to have technological glitches, and they're going to tell them you were off bracelet for 72 minutes. We don't know where you were. And then that forms the basis to lock the person up until we get it all sorted out. And anybody who thinks that having something strapped on their body that's invading their every movement and tracking it for the rest of their life isn't punitive, that's not punitive. Apparently the case, there's either one or two things went on this case. Either the Supreme Court was totally uninformed by a poorly developed case below, or they just flat out don't have any empathy whatsoever. And it's the most backwards Supreme Court in the country. And since I'm not able to know which way it is, I'll just let the people in Wisconsin figure it out. Did you put a bunch of nuts on your Supreme Court, or was this a poorly developed case?
If I'm not mistaken, in the article, they talked about the repeated misuse of the frightening and high quote, that they gathered bunk statistics, and that's how they came to their decision that someone has this frightening and high chance of recidivating, that this really isn't punishment. It's in the interest of the public safety.
Well, it says under Wisconsin law, people convicted of serious sex offenses involving minors are required to wear GPS transmissions on their ankles for the rest of their lives. Okay, what is serious?
Right.
It's electronic solicitation, where you're talking to a police officer posing as a minor that may be only 2 years younger than you. Is that a serious? I know that in my state, they tend to put these things on everybody. What they do is they get a budget.
Yep.
And then the way government works is budgets that are not utilized revert back oftentimes, and they get lesser money for that line item the next year. which means that the incentive is to use these devices, and they look for people to put them on. And we've got to reorient how we do. I mean, we got major problems with what we're doing with GPS monitoring. It could be a great asset if properly used, but I don't think it's being properly used.
There's another, I'd never really considered this in the GPS monitoring stuff. And it says it includes a speaker that can be used to issue commands or reminders, which can be heard by someone within earshot of the offender who has to sit near an electrical outlet 1 hour a day to recharge it. So here you are at your local Wendy's or McDonald's or whatever, and then your leg starts talking saying, hey, it's 5 minutes to curfew or something like that. People would look at you like you just grew an eyeball out of the center of your head. Like what kind of plan? Now you've been humiliated. Is there any sort of constitutional protection against that type of being called out in public to where you're that different?
Probably not in Wisconsin from the looks of it.
Doesn't sound like it. Go ahead.
I'm just looking at the remainder of this article. It looks like they didn't find much problem with it.
No. And it says the reason author, who is Jacob Sullum, in other words, if you're required to wear a conspicuous ankle monitor that is used to keep you in your inclusion areas or out of exclusion areas for the rest of your life, you should shut up and be grateful that you get to walk out in public at all. When indefinite imprisonment does not count as punishment, any burden that falls short of that is a mere inconvenience that can easily be justified by frightening and high recidivism rates, even when those rates are pulled out of thin air. Thank you, Jacob Sullum. I think you kind of nailed it.
Well, he would have a point if these people were not going to be in the free world anyway, but he's making it sound as if that whatever crime they committed would be a lifetime imprisonment. It wouldn't be a lifetime imprisonment under most statutory schemes. So what our legislators have done is created an additional second tier of punishment where they've served their hard time, then they have a little bit softer time. But he's making it sound like that this is, I would be a lot more sympathetic if we were going to the prisons and saying, look, you've got 18 years left on your sentence, and we don't mind if you serve it all because we can afford to keep you here. But if you would like to be out in the free world, we do have technology that has some glitches, and you may end up in a situation where you find yourself uncomfortable, but we will let you out from behind these walls 18 years early if you will agree to this. That's a different deal than going back and saying, well, you've done your 10 years now, you've done your 6 years now, whatever, but you're going to be on this for the rest of your life, and we're going to stack this on top of your sentence. You see the difference?
I do.
If we were using this to empty the prisons and giving people a choice, you can stay in the prison if you want to. Yeah, we're not forcing you to leave. But if you want to make that bargain with us, this is what you're going to have to do.
To me, it feels like he might be referring to civil commitment, though. Maybe, and I could just be reading into that, but that's what I take from the lifetime part of that statement that he made.
Well, I'm not reading the article exactly that way. It says under Wisconsin law, people convicted.
Yeah, that's just the way that I'm catching it from that last little the thing that I just read about lifetime when indefinite imprisonment does not count as punishment. That, to me, that's what that specifically speaks to, is the civil commitment.
Well, yeah, it would. If you can so-called civilly commit a person, and it's not punishment, then it would logically flow that this is not punishment. But if this is a part of your punishment, I'm drawing the line that we shouldn't impose lifetime punishment on anyone unless it's a really serious offense. And the GPS is being stacked, like in Arkansas. They passed a law 4 or 5 years ago that level 4 offenders are going to have to be subject to GPS monitoring when they get out of prison. And it was ex post facto. Well, they asked the sponsor, well, what are you going to do about the funding? And she said, I ain't worried about funding it. It's several years before anybody who's going to be subject to it gets out of prison, and we'll deal with that later. I may not even be here, she was thinking. Mm-hmm. Well, those people did not have any idea that they were going to have that requirement imposed on them. So that's punishment imposed afterwards. And that's not the same as saying we will let you out of your prison cell if you will do this. And to me, they're changing the rules and they're applying this extra monitoring when they would ordinarily just be under regular supervised probation or free altogether.
Yeah. Fun times, man. Hey, so one of our Patreon supporters from Wisconsin sent us in a voicemail, and since we've had this all these articles from Wisconsin, hey, here's a tribute to you, Dave.
Hi, this is Dave from Wisconsin. I just wanted to thank Andy and Larry for doing something so amazing as providing a podcast for sex offenders. It really takes a lot of balls. I'd encourage all listeners to support groups and individuals that are trying to help us. So if you can, donate a few bucks. I went to the Patreon website the other day and see there's only $60 per month for this podcast. That's $15 per episode. That's not much. I think we can all do a little bit better. So thank you, Larry and Andy. Really appreciate it. Thanks. Bye.
Thanks a bunch, Dave, for phoning that in. And
Thank you, David. I can't fake that accent.
He's in Wisconsin.
He could probably do a better job with my southern accent than I can do with his. But yes, I really appreciate that, and maybe he can enlighten us on how this lifetime GPS is being applied, and we'd appreciate any feedback that would help us understand what's happening in Wisconsin and how we got to this state of affairs with the Supreme Court finding everything they want to do to be okay.
And because he mentioned that it takes a lot of balls, I have balls, and I will send you one of my blue balls. So I will need, send me your address, Dave, and I will get one mailed out immediately to you right after the holiday weekend.
We do have blue balls, don't we?
I have 199 left.
199 blue balls.
I do. Well, this next article, please help me with this last name again, Larry. This article is about polygraph testing and treatment of sexual offenders, written by Jennifer
Kamarowski.
Okay. I don't know that I'm going to ever figure that one out. We've covered this time and time again about polygraph testing, and a clip in there, a quote. It says, "There's no objective way to measure the accuracy of a polygraph, but proponents claim the value is in increased disclosure of information and deterrence of offending," which is what you have said is basically just boo games you into saying, yeah, I did whatever I did. It's not actually the value of the polygraph itself, but it scares you into revealing information.
I agree with Jennifer. I've done an about face on the polygraph after having received a lot of background from sources in the profession that I cannot reveal that have told me that this is nothing more than voodoo. I have learned though that regardless of it being 50-50 at best in accuracy, it does inspire people to come clean, because everyone that we've administered one to in the practice of law has come clean when they showed deception and confessed that the polygrapher was onto something. And I think that's probably the reason why they're so commonly used in sex offender supervision, because the person becomes frightened and they make concessions and confessions and admissions that they shouldn't make. And then those form the basis of the polygraph of what happens on the revocation, and not the failing of the polygraph itself. That'll be very secondarily mentioned, but the actual supervision violation report will say that at the conclusion of a polygraph that there was a post-polygraph interview and offender admitted X, Y, and Z. And that's the basis for the revocation. And it's tragic that people are giving up their freedom because they're being snookered into making disclosures that they should simply say, I don't know why the polygraph says what it says, or sure, whatever you say it's saying, but I'm telling you the truth. And they should stop.
Yeah. Jennifer says in the article, the lack of scientific support for the use of polygraph in, I don't know what PCSOT is, but SOT would be sex offender treatment. Oh, post-conviction sex offender treatment. Should be of serious concern where individuals are at risk of being deprived of their freedom. So yeah, here we are saying you have some voodoo, something that may be 50-50 at best. So flip a coin. And if I don't even think it's 50-50, frankly, Larry, I think it's 75% against you, because you're going to be nervous. And the system could read that to some degree that you are being deceptive. And now you lose your freedom because you were about to poop your pants because you were scared. I just don't see how any way can be measured that this is a fair way to treat somebody. And you know, you're not like, I don't know, you don't have to be in by dark. You're actually going to go sit in the cell for a while and end up having to spend money on commissary and have crappy phone calls with your loved ones.
Well, but the people make the admissions and the confessions after the voodoo takes place. So that's where the problem. That's where we're failing in educating people not to make these admissions. No matter how much they hammer you and say you failed, you have to say, well, if you say I failed, you say I failed. I'm telling you the truth. I'm not advising anybody to lie. I'm not advising anybody to do anything. But I'm telling you that if you make admissions, then you're going to go down in all likelihood.
Now, granted, even the better procedure would be to not do anything that's against your supervision requirements. However,
I think I've made a standing offer that I'll renew on this podcast. If someone can show me a petition to revoke supervision, whether it be a probation or parole supervision, that all the petition says is that the person showed deception on a polygraph, and it stops there. It doesn't say that they made any admission to any violations of terms of supervision or any criminality, that we are seeking that this parole board or this court revoke their supervision because they showed deception. I've got $1,000 offer. I want to see one of those that I can validate as being filed with a parole board or with a court. I have not yet to see one.
I have a friend who says that he came up shaky on one and they locked him up for a week. He didn't have a revocation.
That's not the offer.
Okay.
The offer is that there has to be a petition to revoke.
Okay.
I have no doubt that they lock people up for coming up shaky.
That's bizarre.
But I want to see whether they're seeking a full revocation by either the parole board or court, and that's all they've got to offer the board or the court is that they show deception. And the petition stops at the deception. It doesn't say, and they made admissions.
Right.
It just said, we did a polygraph, and on question A, they showed deception. Therefore, we ask that you revoke this person's supervision.
Well, explain to me what would be the just cause behind getting someone to go sit in the tank for a week or whatever because they came up shaky?
Because they can.
I wish you would give me different answers.
That's the only answer there is.
I know.
The probation authorities in many jurisdictions are allowed to arrest and detain people for various numbers of hours without bringing any charges against them. And they need to notify the court. I think in my state it might be within 72 hours of a detention that they placed a hold on an offender, and they need to tell the court why and ask the court if it wants to continue it. At the end of that, if they choose to not present the court with anything, theoretically the hold order dissolves. But so the answer is they do it because they can.
Yeah.
Your lawmakers gave them the power to do that.
And where'd the lawmakers get their power?
I guess from the people who elected them.
Got it. Just wanted to hit that home yet again.
Now, every state doesn't empower their supervising authorities to arrest people. I think your state, they have to get a warrant. Last time I talked to a legal professional.
That is my understanding too. They still have to warrant you.
They have to go. Well, in my state, they have arrest and hold powers.
Okay. Yeah, that is my understanding as well. Well, your favorite publication, the New York Times, is an article about the right way to fix prisons. And while this, the New York Times is no friend of the current administration. However, in here is a Republican senator named Chuck Grassley who has seen the light, I guess you could say. And while states for the last several decades have been making moves to make prison sentences a little less draconian, the federal side hasn't really followed through with that, followed the state's leads. And what he said is effective change will come from both limiting how people get locked up to how they serve. Even skeptical Senator Chuck Grassley, who is the chairman of the Judiciary Committee, back in reforms like good time credits, etc., along with changing how the sentences, how they are carried out. That is how you'll end up with effective fixing prisons.
Well, I'm going to give Grassley some credit. He's a senior senator from the state of Iowa and chairs the Judiciary Committee because the Republicans have the majority in the Senate. We were on our way in 2016 towards seeing some bipartisan reform in the federal system until the middle of the summer when the presidential campaign really heated up, and the law and order presidential candidate at that time scared the bipartisan supporters away because we were told that we're in the middle of a crime epidemic, which was untrue, and the reform that was moving stopped in 2016. Now we're back, and we have the same president, but we have dissension within the administration. We have the really hardliner Jeff Sessions, who doesn't want to give an inch on changing anything, who's the Attorney General, and then we have Jared Kushner. I believe I'm pronouncing it right.
Kushner, yep.
A Trump administration official who has seen the light because I think his father got sent away, and Kushner is pushing for reform, which means within the Trump administration we have dissension, and the Attorney General has more authority by law than a presidential advisor, which puts us in a position where a lot of the reforms that were implemented by the previous administration to try to curtail and contain and reduce the prison population, they're being dismantled, have been dismantled by the Attorney General, seeking the maximum penalty, filing the most serious charges. They've defunded halfway houses, which cuts down on how quickly people get out of prison on the federal system. Normally, you're going to get 3 to 6 months in a halfway house, but if they cut all the contracts with the halfway house providers, there's no slot open for you, so you spend that entire time in custody. My optimism is that the more moderates, the few moderates that are in the Trump administration, since they're related to the president, may win out, and we may get some reform done in the federal system going forward. And that's my optimistic rose-colored glass view that we actually are going to be able to get it done. There's a lot of people that are on board on the Republican side.
I don't know if you followed much about the First Step Act, but we've talked about some other issues. If you could, how do I word this? Where if you tried to introduce a bill that helped everybody and it would never make it, would you curtail the bill back to get something, or would you just take all your marbles and go home? Which approach would you rather take?
There's an easy one for me, but it's not easy for a lot of our supporters because they see it throwing people under the bus in their view. And if things are bad, prisons are bad, which I think they are, if registries are bad, which I think they are, then I'm going to save as many as I can. So I'm going to take a compromise. If I can't get as far down as I'd like, I'm going to take as many people as I can out of prison and off registries, and I'm going to continue to come back and seek future reforms in the out years. But I'm not going to say, well, it's all or nothing. That's just not the way I look at it. Can you
give me the reason why someone would say all or nothing?
Well, the reason, the most as best I understand it, they think that the changes, it's only a one-shot deal. That if you leave these people behind, somehow or another we're locked in this, and that those people will never ever be dealt with. So if we get the low-level drug and nonviolent offenders, and we curtail the harshness of their sentences, somehow or another we can't come back and address the harshness of other sentences. I don't believe that, but they do. They believe that with all their heart. And they're right in terms of some of the people that worked on the drug offenses. They're not going to be nearly as concerned about other offenders, and they may peel away. But that means new people have to step in, and lead the charge. But it doesn't mean it's so absurd. What do they think we're going to do? Close down the legislative processes, and we can no longer propose legislation?
That's it. We're done. We go home.
Yeah. It's like, come on, folks. We convene every year or every other year, depending on the state, and we can come back and revisit these issues in future sessions. And in the meantime, we've saved lives if we get people out of prison, even though we don't get everybody out we'd like.
To me, it feels like that makes. I see the no man left behind, and I'm going to take all my marbles, but they would just be like, I don't care if I don't help. If you don't want me to help you get 10% of your population out of harm's way, it's no skin off my back. I don't care. So why wouldn't you accept the 10%? Now you could go back go around and try and get another 5 or 10 or 20 or 50%, whatever you can get. You did something for some people. Why? Hey, the Titanic is sinking. We can't save everybody. Everybody stay on board and drown.
Well, unfortunately, there were people who probably believed that at the time.
Certainly.
But I'm glad they lowered as many boats as they did, as many as they had. I think they lowered almost all of them.
Sure. And I know that it wasn't a fair selection. They didn't try and cram everybody on the boat. First class passengers, put 3 or 4 people on a boat, and then, as they filled up. But just using the example of a sinking ship, try and save as many people as you possibly can instead of saying, oh, can't save any, so everybody go down. That's absurd.
Well, it's a view that's held out there that we're throwing people under the bus, and I don't buy into the notion, but that's what people say.
Well, in some good news from the Register Citizen, pardon lifts requirement to register as a sex offender. And this is like the shortest article I've ever seen, so I made 4 bullet points to cover it. Guy convicted in 1995 of a sexual offense. He applied in 2013 for a pardon. The Pardon Parole Board granted the pardon. In 2016, he was arrested for failure to register. And then just this past Monday, the Georgia Supreme Court said that the pardon removed his requirement to register. So he's done. That's pretty cool.
It's pretty cool. And let me dig a little deeper into this. The state of Georgia has one of the best systems for pardons in the country, believe it or not. They don't politicize it to the extent you can't totally remove politics from it. So the executive, the governor, does have some influence on who serves on the parole board, but they have a as well insulated position as you could possibly have. They do their business in secret, and in most states where it's entirely a governor executive decision, you'd seldom, if ever, see a pardon for a sex offense. But in Georgia's system, they have the governor doesn't pardon people. The Georgia Board of Pardons and Paroles do. And they answer they don't have to be reelected by the people, and they have the autonomy to do what they want to do. And that made it possible for him to get a pardon. The great thing is that those liberal do-gooders on the Supreme Court in Atlanta actually said that a pardon means complete wiping away of the effects of the conviction, which means his 1995 guilty plea is as if it didn't ever happen. He started from scratch. He can serve in public office. I presume, I haven't investigated this, I'm presuming he's able to own a firearm, but apparently this is a full restoration. And so kudos to the Georgia Board of Pardon and Parole. Problem is there's people in Georgia who want that anonymity and that secret meetings, and they're insulated. I had an offender who was in advocacy tell me how horrible that was that they could meet in secret. I said, well, why don't you just go ahead and put it out in the public and find out how many pardons you get? I mean, you want them to, what you're advocating for would make sure that you would never be considered for a pardon. The fact that they do it the way they do is what made this possible.
My understanding is that the governor appoints the people on the board there, but then they don't answer to, I mean, I don't know who they answer to directly, but I don't think they even answer. They can make their decisions without having the ramifications of politics.
They answer to themselves.
Okay.
And that's the way it has to be for them. Like I say, that there was a time in Georgia where the eligibility for a parole and a life sentence was 7 years. It's not that way now. I think it's like in the 20-something years.
30, I think.
But they've escalated it. But a lot of people got released from prison on life sentences in Georgia under this system they have after serving 7, 8, 9, 10 years.
Mm-hmm.
The board can't do it now because they must serve a much longer period of time to be considered. But they had autonomy, and they actually use that discretion to do good things. And did they get every single decision right? No. I'm quite confident that someone that they let out did something that they shouldn't have done. We're dealing with human beings, and the only way you can make sure is to keep everybody locked up forever.
Yeah. Well, we received an email message from someone who was so kind as to not leave me a way to contact them back. And I was really with him at the beginning. He left a comment about the GPS monitoring and why it's one of the 7 deadly sins. And we kind of had fun with the 7 deadly sins, why the reasons are. And the comment took, the fairly long email rant took a really bizarre turn. And the reason why I want to address this is because it hit home to me because of the way the person was making comments that were anti-Semitic and very racist in nature. And it had conspiracy theory written all over it. So first of all, if you want to leave anonymous comments, I encourage you if you feel like you are threatened in some form or fashion. But the systems are all under my control, I guess, short of some sort of court subpoena. But I control all the systems. If you want to engage, please leave an email address so we could have some sort of dialogue back and forth. But if you're not comfortable with that, feel free, don't. But I cannot let this go. I've talked to so many people and they're like, hey, you should just let it go. But with the rallies that happened where the Nazis are marching in the city squares and things get violent, and with all the hate speech that's going on lately, and I come up from a Jewish family and I had Hebrew school teachers with tattoos on their arms, these comments to me are abhorrent. And I just can't let it go that this person, it just makes me so mad that I even start losing my way to speak. But he says that the way that anti-Christianity is being taught in our system is that it's leading America to become a third-rate land of mixed, tan-skinned, raceless, gender-ambiguous wage and tax slaves for the benefit of the illegal land of Israel. This is the biggest bullshit email message I have ever seen, and I'm really, really angry about it.
Well, I read the thing myself, and the first sentence or two was making some sense, and I thought, wow, this is going to go somewhere. But
I got excited at that point. I was like, sweet, I got to read this.
I felt that it went off the deep end as well, and I have, having grown up in the South and then matured and gotten away from those racist views that were so prevalent, I would strongly denounce that as being racist, and I don't know what to say about someone who would write that. I just don't know how you can. I don't know how you can have those feelings about another human being.
It really pains me.
A superiority, and that to put a whole class of people as being inferior, and that, I mean, it was in the presidential campaign that kind of about being the thugs and criminals or whatever the terminology was. That kind of thing was painful. I live in a state where we have a broad diversity, and those remarks were very hurtful. That about the thugs and criminals coming up from south of the border. Just for the listeners who don't know, my state, El Paso, is right near our border, and El Paso has one of the lowest crime rates in the United States, and it's a very tan city.
I can imagine. I can tell the person, if you're listening, I don't care if we have a scorched earth policy. If these comments make everyone run away, we can shut down the podcast. If these are the kind of people that we have listening, I don't want you here. But you are from North Carolina, I believe. Feel free. Come at me, bro. Come on. Let's go. So let's move on to this Amazon article where they are selling facial recognition to law enforcement for a fistful of dollars. And how much is a fistful of dollars, Larry? It's $12 a month that they are selling the algorithms, the services that they have at their Amazon Web Services for $12 a month to do facial recognition. That means the police can upload their body cam photos. They can upload all kinds of stuff. And with that technology, they'll be able to tag people. I'm pretty sure you're going to have a problem with this one.
Well, I don't know why that. I mean, the companies are being run by the most honorable and people with the best of intentions, and I can't imagine that we would have any objection to the police running their body cam through Amazon to figure out who people are, or through any social media outlet, anybody who has images of folks. Or what would be the problem? If you got nothing to hide, why would you object to that?
I hear that comment. God, if you have nothing to hide, why wouldn't you go down to the police office and give a testimony or something like that? You're not even a suspect, are you? But that's why we have the Fourth Amendment, right?
Well, I mean, I was a little tongue-in-cheek there,
I know you were.
But I am struggling with this because, I mean, we do encourage entrepreneurship in this country. We do encourage the evolution of technology, and this technology is out there, and people voluntarily share it. They don't think about the ramifications of what it can be used for. And then if the company shares it with law enforcement for whatever their reasons might be, you didn't really have an expectation of privacy if you voluntarily shared it. So I do struggle with it. I struggle with, if you're out in public, the courts have said you don't have an expectation of privacy when you're in a public place. If you're captured in a public place and you've got video and images of you in a public place, and they're able to match that up and tag and see who you are with existing technology, what is the harm? Well, they can build a profile of what you do and where you are. They could possibly label you as a subversive if you're hanging out at protest rallies. And I know in Albuquerque we've had extensive discussion about the police department videoing people that are at peaceful protests. And I suspect they were doing exactly what you're describing. They're going to take that video back to the cutting room floor and figure out who was there.
This isn't terribly different than the whole metadata thing that went on. This is probably 10 years ago, where they would they're not necessarily capturing your phone call, but they capture who you called, how many times, and they can build a very elaborate picture that, if you're calling your boyfriend or girlfriend and if you make that connection with a particular person 10, 20, 30 times a day, that is a person of significant importance to you. If you call Planned Parenthood, they can build a profile of your political views, just knowing roughly who you call or who you're being called from. And this
Absolutely.
would ultimately be the same thing. But now they're getting down to the point where once they have the name associated with the photo, now they can track your movements across. And I've heard this then be labeled as a restriction against your First Amendment liberties, that you are no longer free to assemble because you know that you're being watched, or you feel that beyond just like traffic cameras to observe the flow of it, but they are actually watching you. Now you'll censor yourself, and now you've kind of covertly lost your First Amendment.
That's where I'm afraid it's heading. And I was going to say that not only do you have the social media pictures, but as a result of the Real ID Act that was forced down our throat by the federal government, that the states are struggling to comply with because they don't want to lose their precious federal funds that everybody hates. All your photos in your driver's license databases are digitized, and they can do a facial recognition scan of the. I don't know how many milliseconds or how many seconds or how many minutes, but they can take their photos of you, and they can do a facial recognition check through the for motor vehicle through your driver's license photo, and they come up with a reasonable accuracy in terms of getting a range of people that you might be. It's amazing that they can run it through millions of photos and they can come up with 6 people that they think you might be.
Yes, they might not get you, but they get who you are not.
and that's just amazing how I think that, like when the Supreme Court said that your cell phone cannot be searched as incident to a lawful arrest, that we've had the doctrine for a long time that if you're lawfully arrested, that they can do an inventory search of your vehicle and of your person, because we don't want you to say that you had $37,000 in your pocket that was stolen. So they can inventory your property and they can do a search. Well, the Supreme Court, since the justices are largely carrying cell phones, they recently, the last few years, said, well, no, you can't inventory that telephone. You can take it into custody and save it, but you can't search the phone. And I think that as the courts, as cases are brought before the court, people argue these issues, the court may find themselves identifying with some of these scary, frightening things that may happen that you couldn't have imagined when the technology was invented. People that invent this technology, they're not usually sitting around sinister trying to figure out how to screw people. They're not saying, gee, if we could just come up with this technology, we'll be able to get bad guys. They're figuring out trying to how to make money and make people's lives easier. And they're trying to sell stuff. That's largely why things are invented. Would you agree?
Definitely. Yeah, I mean, they're certainly going after some sort of, they see a reason to have this in there, like uploading your pictures to the Googles and the Facebooks, and they have the facial recognition, saves you the effort of having to go tag everybody. So you say, I want a picture of my girlfriend, and poof, now a whole bunch of pictures of your girlfriend and maybe not even just ones that you took, but ones that are on other people that you might know. Now you have other pictures. Maybe now you find out that your girlfriend has another boyfriend that you didn't know about.
I don't know anything about that, Andy. Does that happen?
I'm going to stay out of that one. Let's move on. We're running long, so let's hit this last article here. This one just kills me. We have to come up with some sort of category to classify something like this. But from the ABA Journal, prosecutors say use of condoms manufactured outside state made sex crime a federal offense. I get the notion that if you take someone across state lines, that makes things a federal crime. But having a product that was made in another state that you use to commit your crime now makes the crime itself something that's a federal offense. This is just bizarre stuff to me.
It's a tragic trend that we've seen evolution. And back in the J. Edgar Hoover days, FBI director, Mr. Hoover didn't want a lot of things to be federal crimes. He wanted things that were easily solvable and that he could get good press for. And he didn't want his bureau bogged down with investigating what he thought belonged in local jurisdictions. Much has changed since Hoover's days, and particularly in the last 20 years, federal overreach of trying to establish a jurisdictional hook so they can prosecute. and they're using more and more tenuous hooks about where the device was manufactured, where the camera was. I mean, I'm striving to have a lawyer that I know write something for us to explain the evolution of some of the tenuous jurisdictional hooks. I'm going to add this one to the inventory of things where I think it's overreach, but it's an unfortunate trend. And I say over and over again, as long as the voters are willing to give the resources to prosecutors that afford them the opportunity to make these cases, they will continue to make them. If you're irritated about the overreach, one way you stop that is by reducing the resources that the U.S. Attorney Generals and their assistants around the country have access to. They will have to pick and choose what they prosecute.
But
just
come
that
on,
simple.
But, I mean, let's just assume that you used a vehicle in committing your crime. Your car was most likely made to some degree overseas. So now you're like on the Interpol most wanted list because you drove a Toyota that was manufactured partially in like Alabama, but parts of it came from Mexico and Japan. So now you're an international felon.
Well, it's I don't think it's quite that bad yet, but it's within the borders of the United States. There's some various tenuous jurisdictional hooks, and they allege in this case that the use of the cell phone to take pictures, but the cell phone, it may have been manufactured in another state. If the photos were made and kept within that state, I don't see an interstate connection there.
Right.
But they use it for gun charges. I mean, they do all sorts of ways to gain jurisdiction. And like I say, we would like to produce a document that we can publish and put on a blog to explain the evolving reach of federal prosecution. It should scare the hell out of conservatives who claim that they're against that, and it should inspire conservatives to begin to defund U.S. attorneys' offices, because one way you can stop them is if they don't have the funds, they can't do it. If you have 50 assistant U.S. attorneys in your office and you get cut to 30, you have to pick and choose what you have those 30 do. And you may have to say, well, gee, some of these jurisdictional hooks that we're alleging, we may need to back off of those and argue cases where we have clear jurisdiction. And that was the way we did when Hoover was running the FBI.
It does feel like a conflict if they're all about some small government that they go down this path so heavily of being about some law and order and prosecution and all that stuff.
Well, oftentimes they never get challenged to square their inconsistencies. It's an intellectual come to Jesus you have to have. I don't want to use that terminology for some people find that offensive, but you have to have someone challenge you, and you have to open your mind and say, I do. It's like the real ID. That's a big federal intervention. Most conservatives claim that they were against a national ID. I heard all my life, we don't want a damn national ID card. But after 9/11, they quickly railroaded that Real ID Act through, and they required the states to revamp their licensure issue. These people who believe in states having the right to decide how they do things, they're requiring that the state IDs meet certain standards in terms of who they can issue them to, who they can't issue them to, how that they produce the instrument itself, how it's manufactured, what type of security measures it has in it to protect it, and then they're requiring people to re-authenticate themselves that have been in the system for decades and decades. So you have people who claim that they're against Big Brother forcing the states to spend gobs of money and the private citizens to spend gobs of money, particularly married women who've gone through a couple of marriages in their life. They have to show each name change with a real source document. And they may not be in the same state where different changes in their life occurred. And it's very expensive. And some people end up without a license. Their other one expires. They can't do anything because of Real ID. And this is the very thing that conservatives normally rant against. We don't want to do these things, but yet, and you ask them, how do you justify doing this? And they say, well, it's national security.
Yeah.
We want to keep people safe.
Right. Larry, do you have anything else?
I'm done, Andy. Great podcast.
Thank you, Miss Lea Bickerton, for joining us. You can find us at registrymatters.co. Follow us on Twitter, patreon.com/registrymatters, all those kind of places. Just Google search Registry Matters and you'll find all the places. Thank you so much, Larry. As always, it's a privilege to have you on.
My pleasure to be here, Andy.
Bye.
Good night.